Insider just leaked this huge important news about Ripple XRP. U.S. Representative Brad Sherman recently advised the Securities and Exchange Commission, SEC, to go after crypto exchanges that supported Ripple's XRP token. However, in a recent interaction with Fox Business journalist Eleanor Tourette, Sherman made another claim against the token. Welcome to the Finance Up channel. If you liked this video, don't forget to like it and subscribe to the channel. Do you think the analysts are right about XRP? Write the answers in the comments. Giving away 500 XRP at the end of the week. One random subscriber will receive XRP coins. Take a look at the instructions in the comments section. All you need to do is write the word XRP, watch the video to the end, to like and subscribe. The Securities and Exchange Commission has, as expected, filed an objection to Justice of the Peace Annalisa Torres to the decision of District Judge Sarah Net-Byrne, in which she decided to hand over to Ripple the documents for William Hinman's speech. Recall that this is the third time Judge Net-Byrne has ordered the SEC to provide these documents. The SEC has also requested permission to file additional information, a 30-page opening statement and a 10-page response to future objections from Ripple's lawyers, which will combine objections to all three decisions. In turn, Ripple's lawyers filed their objection to Judge Torres on this issue. Justice of the Peace Torres has already made some decisions, partially granted and partially rejected the request of the Securities and Exchange Commission for additional information. #XRP community #SEC.gov #Ripple #XRP. In connection with the SEC's objection to Judge Net-Byrne's ruling on the Hinman speech documents, the SEC's motion to file a 30-page opening brief was denied, limited to 20 pages, but its request to file a 10-page reply brief was granted. According to the ruling issued late last night, Judge Torres rejected the SEC's request to file a 30-page opening statement, which the court limited to 20 pages, and the court granted the Securities and Exchange Commission's request to submit a 10-page response to Ripple's upcoming response to its objections. Ripple objected to the SEC's request less than 24 hours ago. In addition to the fact that the SEC said it wanted to object to Judge Net-Byrne's three rulings regarding the decision on the Hinman document, Ripple noted that the agency did not provide a justification for why its request for an increased opening statement should be granted. The blockchain company called on the court to completely reject the request, since it exceeds the established limit of 20 pages for objections to the rulings of magistrates. The SEC's request for a brief response is premature at best. The Securities and Exchange Commission has not even seen the briefing of the defendant's opposition yet, so at this stage it cannot conclude that there are arguments that it has not had the opportunity to consider. He also did not offer any other justification for the answer, Ripple noted. Ripple also pointed out the SEC's delaying tactics yesterday and urged the court not to allow the agency's actions to delay serious consideration of the court case. For your information, Judge Torres also granted the request of the parties to set a deadline of July 28, 2022, by which the parties who are not parties to the process can provide their information regarding expert reports. #XRP community #SEC.gov #Ripple #XRP. The court has entered an order setting a deadline of July 28, 2022 by which any non-parties must move to seal portions of the Daubert motions or else waive objections to the court's ultimate ruling on the parties' sealing applications. The Securities and Exchange Commission reiterated that its proposed amendments are part of an effort to protect the identity of its 5 expert witnesses. According to the SEC's letter, one of its experts was seriously threatened and harassed after his name was disclosed by lawyer John Deedon, who is asking the court to represent XRP investors in the upcoming Daubert test. Based on this, the SEC is not ready for other experts to suffer the same fate as the first witness. In U.S. federal law, the Daubert standard is a rule of evidence regarding the admissibility of expert testimony. A party may file a Daubert motion, a special motion filed before or during the trial, to exclude the presentation of unqualified evidence to the jury. In order to protect the identity of SEC experts, the SEC proposes to edit the name of each expert, as well as identifying information, including contact information, information about education and work experience, the SEC noted. The Securities and Exchange Commission believes that the general public can use some details to decipher the identity of a witness, mainly through online search engines or social media platforms. The SEC also seeks to conceal the identities of consulting firms and their employees who assisted experts in their reports. These proposed amendments are narrowly tailored to ensure the safety of witnesses, and therefore the SEC's application must be granted, the SEC added. In addition, the SEC proposes to edit 4 documents in order to prevent the disclosure of financial information of experts 1, 3, and 4. According to the agency, the proposed corrections are necessary because the disclosure of financial information of experts is not relevant to Dobert petitions, and this may jeopardize the confidentiality of experts. Notably, Ripple also edited the names of third parties from its reports in support of Dobert's proposals. The SEC does not object to the defendant's statement. If the court orders that the names of third parties be sealed, the SEC will edit all such names in accordance with the redactions proposed by the defendants, the Securities and Exchange Commission said in a letter. In conclusion, the Securities and Exchange Commission stated that other third parties whose information was cited in the reports of the parties may require that this information, which is considered confidential, be sealed. The U.S. Securities and Exchange Commission, SEC, is trying to block the holders of Ripple, XRP, from helping to protect Ripple and prohibit attorney John E. Deaton from any further participation in the proceedings. In its official objection submitted on Tuesday, the regulator, together with lawyer John E. Deaton, opposed the decision to recognize 1,746 XRP holders as amici curiae. Amici, plural. Amici curiae means friend of the court, an individual or organization who is not a party to a court case, but who is allowed to help the court by providing information, experience or ideas. In this case, in support of Ripple protection, Deaton has 3,252 affidavits signed by token holders, which essentially state that they are victims of an SEC lawsuit against Ripple as a result of lost profits. The holders claim in written testimony that they either did not take legal responsibility for the purchase of XRP, or bought tokens for utilitarian purposes and not for investment purposes, or did not buy on the basis of promises made by the company and its representatives. However, in its objection to XRP holders, the Commission stated that they were trying to act beyond strictly legal issues. SEC writes, Mavant does not offer instruction on legal issues. Instead, they want to present arguments based on 3,252 affidavits, confirming certain facts. Quote, the current price of XRP for today you can see yourself on the screens, and the trading volume for 24 hours is $1,294,436,065 US. We are updating our XRP price in US dollars in real time. XRP has dropped 4.08% in the last 24 hours. Do you think XRP will be able to win the court and restore its former price? Write the answers in the comments. That's it for today. Thank you for watching this video to the end. If you liked it, then don't forget to like it and subscribe to the channel.